SJC-11739, Guardianship of V.V.
Attorney Goldis.
Good morning. My name is Glenna Goldis. I represent the mother in this case who lost custody of her one-year-old son to a guardianship decree. Parents have a fundamental right to raise their children. In other areas of law, parents are appointed counsel when third parties seek to remove their children.
They're all third parties? Or just the state?
No, Your Honor. There are other instances where the state is not a party, but the parents are appointed counsel. One example is when a private party is seeking to terminate the parents' rights, then Megan holds that those are the same rights as when the state does, and so the parents are entitled to counsel. Another scenario is in what were termed CHINS hearings at the time, but they're now CRAs, when DCF was not a formal party, but it was possible that the child might end up in DCF care. In Hillary, this court found that parents were entitled to counsel in that scenario as well. But the parents sued for guardianship, they're not appointed counsel, and this gap in the guardianship law violates parents' due process rights. It also violates their right to equal protection of the laws, because they are not being treated the same as similarly situated parents. Finally, the gap undermines the child welfare statutory scheme. In this case, a 17-year-old mother was sued for guardianship. The petitioner had counsel, and the mother did not. The mother contested the petition at the first few hearings, but then she signed a blanket waiver of her rights. The court issued a decree of guardianship that let the guardian have total control over the mother's contact with the child. 5 months later, the mother tried to undo that agreement that she made by filing a petition to remove the guardian. This time, the mother had counsel. After a 2-day trial, the judge found in favor of the mother, and the mother regained custody. By that point, the child was 3 years old. He had been 13 months old when he was first removed from her. And the probate and family court had heard the matter on 19 different days. The original guardianship decree violated the mother's right to due process. In JKB, this court found that parents were entitled to counsel when the state sought to permanently terminate their rights. In Megan, the court found that parents were entitled to counsel when private parties sought to do the same thing. When the state seeks a temporary removal of the child, that right to counsel is statutory, but this court has repeatedly confirmed that substantial liberty interests are at stake in that context, even when the removal is only for 6 months. And in guardianship, the removal is indefinite. So as in Megan, we're asking the court to find that parents are entitled to the same level of process, whether the petitioner is the state or a private party. They must be appointed counsel.
Now, who pays for that, out of curiosity?
Well, this is the state. They're appointed.
From whose budget do these payments get made, would you say? Attorneys?
Well,
not DCF's, for sure.
It's not DCF's budget. No, they're either from CPCS or they're affiliated with CPCS.
So it's under 211D Section 5, yes?
I can't say that I'm certain about that issue.
Are there a lot of these petitions?
Petitions?
Any idea about the numbers?
Yes, so we have some numbers. They're provided in the CPCS amicus brief. Now, and there's some question about what the numbers mean. So in the last year, there were about 5,000 guardianship petitions filed. But of course, that includes petitions in the classical sense where the parents have passed away or they're totally unavailable. So the number of those petitions that look like the one before us today, where there's some contest, that has been estimated again in the CPCS brief at as much smaller, maybe 500.
And with respect to those, I take it whether counsel would be appointed or not for the parents would depend on their financial status. Is there an indigency requirement here?
Yes, under Chapter 119, which we're arguing there should be a parallel here. Under Chapter 119, there is an indigency requirement, and we are seeking this right for indigent parents. This decree violated the mother's right to equal protection of the laws. The petitioner could have asserted essentially the same claim against the mother under the Care and Protection Statute, Chapter 119. If she had, then the mother would have been appointed counsel. And she would have gained other rights as well, like the right to have meaningful contact with her son, facilitated by Department of Children and Families, DCF, if necessary. And she also would have been entitled to reunification services through DCF.
She currently has custody of her son, is that correct? I mean,
yes.
So technically this is moot.
This is a moot case, but it's, as we just discussed, it repeats all the time and it evades review.
Yeah, no, I understand that, but I want to just be clear that this child is with his mother.
He is with his mother, yes.
So I'm really not terribly familiar with the process here. Someone comes in seeking guardianship of someone else's child. The person, the mother, doesn't have counsel and can't afford counsel. Does the court appoint a guardian ad litem, let us say, to represent the interest of the child, or how does this work?
The court may appoint a guardian ad litem, and the court may appoint children's counsel, but this, it certainly doesn't happen in every case. And again, there are some numbers about this in the CPCS brief, but there are many cases, including this one, where neither a child's counsel is appointed nor is a guardian ad litem. I mean, to be clear, later on, after we filed a petition for remove, a child's counsel was appointed. And roughly speaking, when the case is dragged on a while or it's more contested, then it might be more likely that one is appointed, but it's...
But does the child have would you say the child also has an equal protection right to counsel here?
The argument is different, and I should say the child does have a certain qualified right under the guardianship statute if somebody raises the issue, but there is a different right actually for equal protection. I think the child has, I mean, the child is being treated differently than in the care and protection context.
Right.
And there are fewer protections for the child as well. For example, the guardian isn't vetted in a guardianship action. So
I'm just wondering what the next case is. So the parent gets counsel. Now, does the child also have a right to counsel under your analysis, so that there need to be counsels appointed all around?
Our brief is only about the due process issue. It's an appeal of a denial of a 60B.
Right.
And the due process argument is different for children and for parents.
But in Megan, if I'm recalling correctly, I think both the child and the indigent father were found to have the right to counsel. Isn't that right?
That is right, yes.
It's a practical matter. If the parents don't come into court and someone is petitioning for guardianship of the child, does the court have a responsibility to summons the parents into court and let them know that they have a right to a lawyer and to be represented? Or do you just, is this upon request?
We argue that the right to counsel should attach automatically because particularly in the guardianship situation as distinct from, say, care and protection, the parents really don't know what is at stake, and they might be receiving guidance from outside sources, there might be side agreements, and so we would argue that the court should make an effort to make sure that the parent is served with notice of their right to counsel, and that's what happens in the care and protection context.
So they should be summoned in?
They should be notified of the action, of course, and I think that part of that notice should be you have a right to counsel.
But first-class mail, will that do?
Actually, under the guardianship statute, that's how things are served, is through the mail.
And they are, aren't the parents necessary parties to the guardianship action?
They are, yes.
So they're named as parties, and what you're saying is when they get named as parties, they should be informed either by the judge when they come in, or I guess you would say before, that they have a right to counsel if they cannot afford it. Is that right? Yes.
Okay, so that goes out in the summons, perhaps, the summons that they receive, because they're named as parties. That if you're indigent, you have the right to counsel. If they don't show up anywhere, that's the end of it.
Well, that's a good question. We would ask that also, just as in the care and protection statute, that the parents also be made aware that there are other services available as well through DCF to parents in their situation. And the court would I would suggest should make some kind of effort to contact them. For example, the courts are always using probation to call parties who don't show up to court. So I think that should be done too, and that's in the court's interest because you don't want this parent coming back a few months later as this parent did.
So are you suggesting that new forms have to be created and new rules with respect to how these things are handled beyond just the appointment of counsel for indigent parents?
Well, I think some of them wouldn't be too complicated. They could parallel the care and protection statute, but I imagine that there's some, might be some forms required.
Okay.
Yeah.
Hey, your time is up.
Oh, well, thank you.
Thank you.
Thank you, counsel. Done?